Welcome back to the Manifest Justice Law Corporation channel. My name is Carly Jones, and I'm an employment attorney at the Manifest Justice Law Corporation. It's Saturday, and it was a long week, so I'm tired and I'm a little spacey, but I'm here because we've had some questions from some of the audience viewers, and I would not be doing what I said I would do if I didn't answer them. So today's audience question comes from Gman83, Gman with a double N. 83. And I can give you a shout out, Gman83, because it seems like your username and YouTube profile are anonymous, which means that I'm not concerned about opposing counsel or your employer or anyone subpoenaing your records and finding out that you made all these amazing, wonderful comments on my video. So make your YouTube usernames and profiles private and anonymous, please, when you're going to comment on here, because if you're in the midst of employment litigation or any kind of litigation, I would hate for opposing counsel to subpoena your search records, your computer records, your text records, your phone records, which they often do, and easily see all these searchable things or comments that you've made to my page and harm you in any way. So shout out Gman83 for being anonymous, and shout out for your question. Your comment was basically saying that, yeah, you wanted to know more about ADA and FMLA as well, which I just made a video about that like literally 2 seconds ago before I had to wrangle in little Miss Jada Potato, here she is, for barking at the lawnmowers. So I just made a video about FMLA and ADA, but then in your comment, you said you also wanted to hear a little bit about workers' comp. I figured I would make you a separate video just touching on workers' comp really quick, particularly because I myself am not a workers' compensation attorney. I don't practice workers' compensation. And so I want to come on here and explain why, and again, show where's the line of difference. Workers' compensation and employment litigation are very, very similar, right? Like we are close cousins, first cousins. We are half siblings, if you will, but we are not the same. We're not twins. We don't have the same mom and dad. We are still different. There's a degree of separation. Workers' compensation occurs when you have experienced an injury on the job. Okay, so that's what workers' compensation for. Workers' compensation is to compensate workers who experience an injury or experience a disability, whether temporary or permanent or long-term or not. So for people who fall off the forklift, or for the window washer who falls off the ladder, or who was never given the appropriate supervision when they were on the ladder in the first place. Well, actually, that will probably be like a negligence claim. It's not necessarily a workers' compensation claim unless the window washer was injured when they fell off the ladder. That was unsupervised. If you worked at the 9/11 site, for example, and you had residual injuries from working at the site because of all of the chemicals that you ingested, that would be a workers' compensation claim potentially. That people who are sexually abused, trigger warning, they have definitely experienced an injury on the job and may have developed as well a disability as a result. Workers' compensation is there to compensate and protect and take care of workers who are injured on the job. That shouldn't fall on your independent insurance. That should fall on the employer. They should be responsible for any injury that happens on the job while you are in the course of your employment and your employment duties. Okay. Employment litigation, on the other hand, is not necessarily workers' comp. Employment litigation is there to help people who may have experienced an injury on the job, who may have had like an arm broken, a limb broken, a disability that was developed. But also it's just for people who were wronged in the workplace. There still typically has to be some form of a harm done to the person who was harmed in the workplace in employment litigation, but there are very different rules, regulations around that. In workers' compensation, for example, in California, I speak for workers' compensation because I do not practice workers' compensation. I know some great workers' compensation attorneys doing the Lord's work, but I do not know it from a lawyer perspective. I have personally gone through a workers' compensation claim as a client in California, so I could talk to you from that perspective, and I can talk to you from a very generic educational perspective. But yeah, I don't have a lot of insight on workers' compensation. So from my perspective as a client, and my understanding of the rules and regulations and laws in California is that there are big differences of proving that the workplace caused your injury in workers' compensation versus in litigation. In workers' compensation, it really is for people who are injured on the job. It's really for people who are injured on the job for a work-related injury. Again, the person who falls off the ladder or who is harmed by their boss or manager or colleague, or a customer who is tripped and falls and etc. It's really to protect workers who are injured physically, mentally, emotionally, in the form of a disability, temporary or long-term, by their employers in the course of employment. Employment litigation is more broad, and it's more like if you were fucked with or harmed or disturbed or disrupted in any kind of way, if you were dismissed, if you were transferred, if you were demoted, these are things that won't necessarily cause a disability. It could potentially, depending on the facts surrounding a situation, but typically it may not. Those may not cause a full-on disability, but it's still going to cause you emotional distress. It's still going to cause you financial distress. It's still going to impact you, and it's still a form of retaliation, discrimination, harassment. Think, for example, of the female skyscraper or construction worker or window washer, or gardener. Let's say gardener. Shout out to the lawnmowers and gardeners here in the community today on this beautiful Saturday, also doing the Lord's work, and also protected by a lot of like break laws and regulations. But anyways, let's think of the female gardener who works on a team of like predominantly male gardeners, or even vice versa, a male gardener who works on a team with primarily a female gardening team. And then every single lunch break, that gardener's tools go missing. And when they come back to work, they don't have any of their tools, and they have to go search and find them before they can start working. Whether that's a male employee who's discriminated against by all the other female employees, or a female who's being discriminated against by all of her male colleagues, that's still sex-based discrimination, right? And even though there's not a sexual harassment, and even though there's not like a sexual assault or a sexual-based physical injury that someone might go to workers' compensation for, just the taking of the tools, it's still an employment litigation issue, because that's still harassment, that's still discrimination, that's still retaliation. But again, with taking of the tools, there's maybe not an injury that's caused. Now, if they took the tools, and because they took the tools, now the gardener gets an injury that causes like a limb to break, or a psychological, like a brain disorder, there are a lot of ways that can turn into a workers' compensation claim. But hopefully I'm doing a good enough job of like delineating the difference. When there's not a disability, whether physical or mental or emotional, whether temporary or long-term, it's going to be really hard to bring a workers' compensation claim. Now, once you have that injury, there's also a different burden of proof. You've also got to prove that the employer is at least 50 or 55%. And again, this is where it varies depending on where you live in the country, depending on your law, depending on your state and your jurisdiction. But in California, there has to be at least a 55% connection that the employer caused the worker's injury. So if the worker who's claiming a workers' compensation claim because they fell off the ladder, or the lawnmower chewed up their hand, and so now they can't have their hand, or messed up their back, and so now they've got back issues. But we could actually show through their medical records, or the defense could actually show through medical records, that actually Garner wasn't injured because of the lawnmower or because of the like leaning over in their back. They were injured in a car accident 5 years ago, and it was a massive back injury. And so, yes, maybe working as a gardener with the lawnmower and the like bending and the pulling the weeds, maybe that agitated the back injury, but the back injury was actually pre-existing, and it did not happen in the work environment during working hours, or during in the scope of work activities, work duties. So then there will be some argument there, and that may or may not make the workers' compensation claim go away. So with employment litigation, we're not going to necessarily look at percentages or not. We're going to look of like how much what's the percentage of the work activity that caused the back injury. We are focused on, in employment litigation, we're going to be focused on, was it a substantial factor? Was the back injury a substantial factor in your employer demoting you, firing you, not interacting and engaging in a process to get you accommodations, failing to prevent harassment, discrimination? That's when we're going to get into more issues. And we're just proving that it was a substantial factor. It was a motivating factor in the decision that was made that harmed you, the adverse action that harmed you. But in workers' comp, there's a higher burden. You have to prove that it was more than just a substantial you have to prove that it was more than just a motivating factor or contributing factor to the decision. Holy moly. Okay, this is not employment related, and you can't see it on camera right now, but I am like working on a little like birds and bees and butterfly sanctuary in my backyard. There's like a small section of my garden that I've dedicated to just like wildflowers to support the birds, the bees, and the butterflies. But I'm afraid of bees. I'm afraid of bees and like generally things that fly. So you see me swatting, and then I have to I'm teaching myself not to swat at wildlife right now, and it's very difficult. So if you see me swat, fire me up in the comments, light me up and let me know, like, stop doing that. You are not supposed to welcome the birds and the bees and the butterflies into your garden and then swat at them. Carly, okay. These are the things I'm dealing with, honestly, genuinely first world problems, and like a pure blessing and privilege and honor to be dealing with those kinds of problems versus some of the other problems that exist in our country at this exact time and in our world at this exact time. Okay, I can see the light is starting to play funny games with me and make me look different colors, and I'm swatting at things I'm not supposed to, and I don't know if the lawnmowers are going to start again or not, but I think it's time to wrap this video up. Hopefully, Gman83, this was a helpful video for you. If you want to know more information about workers' comp, comment again and be a little bit more specific and tell me what you want to hear. Again, I don't practice workers' compensation law. It's a separate, we're cousins. We're close cousins with employment litigation. So I hear about it and I refer my clients to good workers' compensation attorneys when I can see that that would be beneficial to them. And if you yourself are dealing with an employment litigation situation, you may want to contact a workers' compensation attorney. But again, I myself am not a workers' compensation attorney. So again, if you have a very specific question, I can research that. I'm happy to research and find an answer for you. Again, I don't like I just don't know. I think that's an unacceptable answer for lawyers to give. So I'm happy to do a little research and give you more information if you want. But hopefully this broad overview was helpful. And one more tip I will give is that not all employment litigation cases are workers' compensation cases, but because I want you to be protected on all edges and all formats in all ways that you can be. And a lot of times employers, and so then oftentimes sometimes attorneys will forget the fact that workers' compensation laws and employment litigation laws, they work together, right? They work together. They're cousins. They're half siblings. We work together. We're family. Hopefully this was helpful. Hopefully this was informative. Hopefully this was empowering. Hopefully it helps you get paid. And I hope you all have a good day. Have a good week. And holla at Abala if you have some holla at Abala if you have some employment law questions. Bye, y'all.